covenant not to compete is actually a restraint of trade. It's one of the few restraints of trade that's permitted under the Florida Antitrust Act. It usually takes the form of a restrictive covenant, either in a contract between a buyer and a seller of a business, an employer and an employee, governing what's going to happen after the employee leaves the company, or even with a franchisor. And it basically says that you're not going to compete with that business, you're not going to solicit their customers, you're not going to use their customer lists or trade secrets for a certain reasonably limited period in a reasonably limited geographic area. The statute on covenants not to compete is helpful because it provides time periods that the courts will look to as presumptively reasonable. The courts will presume, for instance, that prohibiting an employee from practicing his trade in a certain area for 2 years is reasonable. More than that, it's going to need to be justified. 5 years if it was a franchise agreement, and 7 years after a seller has sold his business to a buyer, the buyer can prohibit him from engaging in the same business.